Distinguished ladies and gentlemen of the press, we have invited you to this press conference today to address and correct some of the false narratives being sprung and spouted out by the Ijo and Urobo of Warri Federal Constituency. On the 2nd of December 2022, the Supreme Court, in suit number SC/143/2016, Honorable Judge Mene and others versus Independent National Electoral Commission, INEC directed as follows, and I quote, this is very, very important. We need to understand exactly what INEC said, Supreme Court said, because in the press conference, World Press Conference held by the Ijo and Urobo, they have severally misrepresented what the Supreme Court said. And I need to quote it verbatim so we can understand where we are coming from. And the order is, and I quote, an order of this honorable court compelling the defendant, that is INEC, his agent, servant, privileged, and assigns to conduct a fresh delineation of all that electoral ward/polling units of Warri Southwest, Warri North, and Warri South local government areas of Warri Federal Constituency in Delta State for the purpose of future elections. End quote. This was not implemented before the 2023 general election. The above decision of the Supreme Court was given on the only live issue in the suit, which is the prayer with regards to section 114, subsection 1, which provides that, and I quote that section, the Independent National Electoral Commission shall review the division of every state into constituencies at intervals of not less than 10 years and may alter such constituencies in accordance with the provisions of this section to such extent as it may consider desirable in the light of the review. Consequently, since the last delineation of electoral wards and polling units was done more than 10 years ago, it ordered INEC to conduct delineation of electoral wards and polling units in the Warri Federal Constituency. It must be noted that the only other reason for the delineation of wards and constituencies is in section 114, subsection 2 of the Constitution of the Federal Republic of Nigeria as amended, which states that, and I quote, 2, the Independent National Electoral Commission, INEC, may at any time carry out such review and alter the Constitution in accordance with the provisions of this section to such an extent as it considers necessary in the consequence of any alteration of the boundaries of the state or by reason of the holding of a census of the population of Nigeria in pursuance of an act of the National Assembly. None of the events mentioned in section 114, subsection 2 of the Constitution of the Federal Republic of Nigeria has occurred. None. Contrary to the claim of Honorable Judge Mene and others in the suit, and that of the Ijo Urobo of Warri Federal Constituency, the Supreme Court did not at any time in the judgment declare or hold that the wards and polling units of Warri Federal Constituency are fake and fictitious at no time in the judgment. It did not also hold that the INEC voters register is fake and fictitious. That is, the judgment was being misrepresented by Ijo and Urobo. Outside the Constitution of the Federal Republic of Nigeria as amended, the only legal instrument to guide INEC in the enforcement of the Supreme Court judgment is the provisions of section 40, subsection 2 of the 2022 Electoral Act, which provides clearly on what INEC is expected to do using the electoral register of voters. That is, the Commission shall establish adequate number of polling units in each registration area or electoral ward and shall allot voters to such polling units. This is the duty, constitutional duty of INEC, And this is what INEC ought to have done in trying to enforce the Supreme Court judgment. INEC constitutional mandate are primarily geared towards facilitating the smooth, efficient, and credible conduct of elections across the Federation. Its mandate in this regard is administrative and operational within the context of elections. This did not extend to or include A, creation, recognition, or alteration of communities or local government areas. B, conduct of population census. C, ethnic profiling of various local government demographics, boundaries adjustment for local government and states. And lastly, as a court of law to determine which ethnic group owns where. INEC has no business with who owns where. INEC is not a court of law. The duty of INEC, as provided for in the Constitution, is simply to conduct elections for Nigerians. INEC has done all the above in their field work by embarking on the compilation of the list of communities in Warri Southwest, Warri North, and Warri South local government areas in the Warri Federal Constituency of Delta State. Independent National Electoral Commission, INEC's engagement in such ultra-vires acts amount to usurpation of powers and a clear act of administrative overreach, which is not supported by law. Accordingly, INEC can only rely on empirically valid voters register, which includes the biodata of voters in its record and the geophysical spread of the same in the implementation of the Supreme Court judgment. In exercising its power of constituency and ward and polling unit delineation or alteration, the Commission must rely on the provisions of the Electoral Act, Section 40, subsection 2. The Constitution does not empower INEC to act on the basis of contrived and unofficial population figures arising from area views, Google Maps, etc. It also does not empower INEC to determine the ownership of territories, nor does it empower it to create imaginary communities as INEC has done in their field work. To do so will not only violate the clear intent of the constitutional provisions, but also undermine legal integrity and credibility of the electoral process. Therefore, any attempt by INEC to act outside these prescribed conditions will render such actions ultra-vires and constitutionally invalid. False claims of the Ijaw and Urhobo on political representation at their World Press Conference. The Ijaw and Urhobo of Warri Federal Constituency at their World Press Conference claimed that they are denied electoral representation. This is not true. It must be stated for the records that Itsekiri have been very magnanimous in conceding to the Ijaw and Urhobo representation in Warri Federal Constituency. In Warri Southwest, for example, the deputy governor under the Okowa administration is Kingsley Otwaru from Gbaramatu. In Warri Southwest, Gbaramatu in Warri Southwest local government area. The only seat in the Delta State House of Assembly for Warri Southwest local government is today occupied by the current speaker of the Delta State House of Assembly from the same Gbaramatu. The current chairman of Warri Southwest local government area is of Ijaw extraction. And in addition, they also have councillors representing their various wards. In Warri North local government area, the last local government chairman before the current one, Honorable Smart Asukutu, is of Egbema Ijaw extraction. And in addition, the Ijaw also have councillors representing their various wards. In Warri South LGA, one of the two seats of the State House of Assembly, one of the seats has been severally occupied by the Urhobo. Despite this high-profile political representation in Warri Federal Constituency, the Ijaw and Urhobo will not relent until they take all that belongs to Itsekiri, without regards to the Itsekiri majority status in the three Warri local government areas of the Warri Federal constituency. We want to ask the Ijaw and the Yoruba to tell the world in simple terms how much political representation have been given to Itsekiri domiciled in their predominant local government areas, such as Etiop West, Brutu, Sapele local government areas. It is also not true, as stated in their World Press Conference, that, and I quote, the gerrymandering upon which the 1999 general election was conducted in Warri Federal Constituency was grossly skewed against Ijaw and the Yoruba indigenous people of Warri Federal Constituency, end quote. In historical context, the 1992 national delineation exercise held in Warri, as in other parts of Nigeria, Warri polling units, wards, state and federal constituencies was delineated using the same parameters, contrary to the undefended claim in the Supreme Court suit as earlier referred to. In the 1992 delineation, Warri had the following constituencies. 1. 2 federal constituencies occupied by 2 Itsekiri persons. 2. 4 state assembly constituencies. In the same vein, electoral wards in the 2 existing Warri local government areas at that time as follows. 1. 10 wards for Warri South, 7 for Itsekiri, 3 for Urhobo. 2. 10 wards for Warri North, 6 for Itsekiri, 4 for Ijaw, which includes current Warri Southwest local government area. In the 1996 local government creation and ward delineation exercise, Warri North was split with Warri Southwest carved out of Warri North. The ward delineation in the 2 LGAs that were hitherto together are as follows. Warri North, Itsekiri 6 wards, Ijaw 4 wards. Warri Southwest, Itsekiri 6 wards, Ijaw 4 wards. This is to put a lie when they claim in the World Press Conference that it was in 1999 that INEC changed its status. We know what the status has been from time, from history. These words were created by the National Electoral Commission, NEC, and it was its prerogative to do so at the time, and it was a nationwide exercise. In the 1999 constituency delineation exercise, INEC retained 4 state assembly constituencies for Warri, but reduced the federal constituency from 2 to 1. The seat taken from the Itsekiri people was given to the Ijaw of Brutu with less population. This action, which reduced the Itsekiri representation at the House of Representatives from 2 to 1, has put the Itsekiri people at a serious political disadvantage in the state till date. The Ijaw and the Yoruba of Warri Federal Constituency did not see anything wrong in the above injustice. It is also most fallacious, as stated in their World Press Conference, that, and I quote, it is important to draw your attention to the fact that it is the failure of INEC to address these imbalances that led to the Warri crisis, which unfolded in 2 phases, 1997 to 1999, and 2002 to 2003, involving conflicts between Ijaw and Itsekiri, and Urhobo and Itsekiri. And I end my quote there. The world is aware that it was the issue of location of headquarters of the newly created Warri Southwest local government area, which was put at Ogidigwem, Itsekiri area, as contained in the national schedule of local governments till date, and the illegal relocation to Ogbijo by the Delta State government that was the root cause of the crisis. The crisis referred to above was a coordinated genocide program to eliminate the Itsekiri people from their homeland, relying on the Ijaw majority support from all over Delta State and beyond, and the Urhobo of the other 8 local government areas of Delta State. In the course of this press interview, like it has already been done, I've already told you that I invited the chartered surveyor to do the presentation. He has already done that, Actually, I was supposed to deliver this speech before that presentation for clarity, but I will emphasize some of the things I've already mentioned for the purposes of clarity. Findings after the plotting and overlay of the INEC generated coordinates shows that 1. Warri Southwest LGA has 1,287 polling units inside the LGA. 510 polling units are outside the LGA, and 1 polling unit fell in Edo State. The polling unit 289, named Torofak Mene, fell in Edo State. 2. Warri North LGA has 609 polling units inside the LGA. 6 polling units outside the state. Polling unit 651 is falling in Mene River. So the polling units are not found to be in habitable areas, like inside the river, in bushes and swamp areas. We have cases of polling units falling in Ethiop local government and Sapele local government area. 3. Warri South LGA has polling unit 4, polling unit 5, and polling unit 16 are not within the LGA. Even polling unit 16 named Mirugun, like I earlier said, that's supposed to be in Mirugun, is by NRA, between the NRA and DECO, which shows a clear misrepresentation of what it is on ground. In the course of the expert presentation, he has already done that, so I leave that. The above findings show that INEC exceeded its constitutional mandate, and it is in violation of not complying with the 1999 Constitution of the Federal Republic of Nigeria as amended, the Electoral Act 2022, and much more importantly, the criteria and guidelines for fresh delineation of wards/residential areas and polling units in the Warri Federal Constituency. At the beginning, INEC gave us clearly and displayed all the guidelines that were supposed to follow in the exercise. But to our utmost shock, INEC deviated completely, abandoned the guidelines, their own guidelines, and did something very strange. That's why we are where we are now. Therefore, Itsekiri Ethnic Nationality reject the purported proposed fresh ward and polling units delineation arising from the field work done by the Independent National Electoral Commission, INEC. We hereby call on the federal government to thoroughly investigate and prosecute INEC officials that have compromised the integrity of the exercise for causing great embarrassment to the Commission. Objections to INEC's field report on delineation. We have raised serious objections to INEC's field report on the delineation of Warri Federal Constituency. Our objects had been forwarded to the National Security Advisor and INEC and published in some of the newspapers, national newspapers. We have also had some meetings with which our misgivings and objections were robustly stated. Therefore, our objections are in the public domain. The main reason for our criticisms have been alluded to in this press statement. We are willing to answer questions and elucidate on any gray areas that you may have, the press. We expect that our objections will be given careful consideration by INEC in reaching an equitable, fair, just, and most of all, lawful decision. Continuous Voters Registration, CVR. While we are waiting for the results of consultations and INEC decision, we cannot understand the desire of the Ijo and Yoruba to link this mutually exclusive event, delineation, and continuous voters register. One does not, by every conceivable parameter, see how one stops the other. Perhaps they are still looking at the result of CVRO with the analog eyes, or they are parties to rascality evidence in the field report of INEC. Therefore, we condemn in its entirety the threat of Ijo and Yoruba of Warri Federal Constituency at their press conference to peace and security. We deprecate in the strongest possible terms, particularly their threat to shut down strategic oil and gas facilities, as well as other national assets by acts of vandalism and sabotage. We have said this is their usual tactics. when they are on a dodgy wicket. We urge INEC to disregard their threat of boycott and sundry unsavory criminal acts. CVRO is a legal and or constitutional right of every citizen of the Federal Republic of Nigeria who has attained the age of 18. It is an opportunity for those who want to change their voting location, whose voter card is destroyed, and those who want to change the information earlier contained in their registration to regularize their rights to vote and be voted for. Gentlemen and ladies of the press, we thank you for your patience and audience. We will now entertain some questions from the press. Thank you, and God bless you all.